All right, Chapter 11, Property Division. After reading this chapter, you should be able to identify the 5 phases of the property division process, distinguish between separate and marital property, identify the kinds of property subject to division when a marriage dissolves, distinguish between the community property and equitable distribution approaches to property division, list factors courts consider when dividing property and liabilities upon divorce, and describe the paralegal's role in the property division process. First, identifying the 5 phases of property division process. Definition of property. What is property and what property do the parties have? Classification of property. Is the property separate or marital? Identification of property subject to division upon divorce. Which property can the courts reach to effectuate a division of property? Valuation of property. What is the property worth? How and when is it valued? And division of property. How is the property divided? What approaches do the courts apply? The threshold question in a property division case is, does a particular asset fall within a definition of, quote, property, end quote? Some assets are clearly property, such as houses, boats, cars, jewelry, antiques, and artwork. But some assets, such as the goodwill of a business, a pet, or a professional degree, may or may not be considered property depending on the jurisdiction. In the first stage of the property division process, the parties identify all of their potential assets and liabilities, including both tangible property, property that has a physical form, such as a car or cash, and intangible property, property that has no physical presence, such as a patent or a pending legal claim. Distinguish between separate and marital property. Separate property refers to property that a spouse owned before the marriage or acquired during the marriage by inheritance or gift from a third party, and it may also include property acquired during the marriage in exchange for separate property. Marital property refers to property that is acquired by either or both parties during the marriage, other than by gift or inheritance, that is subject to division at the time of the dissolution of the marriage. What kinds of assets are difficult to classify as separate or marital? Disability awards. The majority of courts focus on the underlying purpose of the award. A disability component will be viewed as separate property and a retirement component as marital property. In personal injury awards, the majority position is that the portion designed to compensate the recipient for pain, suffering, or disability is categorized as separate property, and the component designed to make up for economic losses is considered marital. Appreciation and the value of separate property may be classified as separate or marital, often based on whether the appreciation was passive, whether it resulted from market forces or the passage of time, or active, it resulted from effort. You'll see passive and active appreciation dealing with things such as investment accounts, things like that. If it's an account that really just sat there and the value appreciated just due to the fact that the market continued to trend upward, or the particular stock or asset continued to trend upward, but there was no active involvement on the part of the parties to reinvest funds or do anything else with the account, then that's typically going to be considered passive appreciation. Active appreciation is going to be where the parties are active in trading or managing the account to realize the biggest appreciation in the asset. Accrued sick or vacation leave. The courts vary, but will usually focus on the extent to which the benefit can actually be paid or can only be applied to post-retirement health insurance benefits, etc. Can property change from separate to marital or from marital to separate? A transmutation or change can take place in the character of property during a marriage in a number of circumstances. For example, the parties may execute a post-marital agreement and designate certain separate property as marital. They may decide to jointly title the marital home or other property for estate planning or other purposes. So say, for example, the party is, one party owns the home prior to the marriage, then both parties reside there. They can jointly title the marital home, and then it would, depending on circumstances again, lose its identity as separate property and become marital property subject to division. They may treat a separate asset as a marital asset by spending both time and funds on it, such that a court may find it has changed into a marital asset. Again, dealing with real estate, oftentimes if they're going to reside in the home which one party owned prior to the marriage, if they do significant improvements, renovations, both are contributing to the mortgage payment, etc. Sometimes that asset can lose its separate identity and become a marital asset. They may have commingled funds, for example, by placing the proceeds from the sale of separate property into a joint bank account. If they sell that home that was owned prior to the marriage and place the proceeds of that sale into a joint bank account, sometimes that can constitute a change, a transmutation from separate property to marital property. Identify the kinds of property subject to division when a marriage dissolves. There's two approaches taken by the court. Dual property states, the majority of states follow the general rule that only the property acquired during the marriage is subject to division by the court. Property belonging to a spouse prior to the marriage that has not changed in character remains the property of that spouse. That is the approach in the state of Ohio. There is separate and marital property. You'll see on the financial disclosures that are mandated to be filed with divorce proceedings that there is a paragraph in there or a specific lineal designation for marital and separate property. So the parties have to identify in those initial pleadings what they consider to be separate property. All property states, the minority position is that the court may assign any of a spouse's property, including separate property, at the time of the divorce if necessary, to effectuate an equitable division of property. There are three basic issues in valuation cases: which property of the parties should be valued, if the parties have few, if any, assets, or they can agree on a reasonable allocation of property, valuation may not be an issue. The assets most commonly valued are pensions, real estate, and business interests. What is the appropriate date for valuation? Some states establish the date by statute or case law. Most prefer a flexible approach, so that the date might be the date when the parties separated, the date that the complaint for divorce is filed, the date discovery is completed, the date of the divorce, or some other agreed upon date. Who will conduct the valuation and how? Valuation of some assets, such as bank accounts and vehicles, is relatively straightforward. However, in some cases, it may be necessary to have professional assistance, such as an actuary to calculate insurance and pension values, appraisers to estimate the value of real estate, or an expert of some kind to value a professional practice or business, a copyright, or a spouse's contribution as a homemaker. Distinguish between the community property and equitable distribution approaches to property division. The parties may have executed a valid premarital agreement in which they mutually agreed on how their property would be divided in the event their marriage terminated in a divorce or legal separation. The parties may negotiate a mutually agreeable division of their property and include it in their separation or marital agreement for approval by the court. If the parties are unable to reach an agreement, the matter will be tried before the court and a judge will determine an appropriate distribution, applying equitable distribution or community property principles. In the community property approach, a husband and wife hold property acquired during the marriage in common, and each spouse is generally deemed entitled to a 1/2 interest in the property, no matter in whose name it is held. It is based on a view of marriage as a partnership in which both parties act for the benefit of the marital unit. When the community property approach is applied, the marital property is usually divided equally upon divorce, absent an agreement to the contrary. Separate property remains separate property and generally includes assets brought into the marriage, property acquired in exchange for separate property, and gifts and inheritance received by a spouse during the marriage. A minority of the states are community property states. The equitable distribution approach is based on the legal concept that upon divorce, property accumulated during a marriage should be divided between the parties equitably, but not necessarily equally, based upon principles of fairness. Each state adopts by statute and/or case law a series of factors to be considered by the courts when making a property distribution. Judges consider the factors in light of the facts of each case, recognizing that both parties have contributed to the marriage in a variety of ways: financially, maintaining the home, raising the children, etc. A trial court's decision generally will not be reversed on appeal absent error in applying the law or an abuse of discretion. A majority of states apply this approach. Ohio is an equitable distribution state, so you will see typically language in decrees that state something to the effect that the property division, while it may not be equal, is equitable, etc. And typically when parties are entering their agreement on the record, the court will ask them, or the attorneys will inquire of the parties if they are in agreement with the separation agreement, if they believe that the division of the marital estate is equitable, if not equal. So that is specific language that that is utilized in Ohio. Factors courts consider when dividing property and liabilities upon divorce. In an equitable distribution jurisdiction, the following factors are commonly considered among others: the contribution of each party to the acquisition, preservation, or increase or decrease in value of the marital property, the duration of the marriage, the relevant economic circumstances of each spouse, the age, health, station, occupation, amounts and sources of income, vocational skills, employability, estate liabilities, and needs of each of the parties, and the custodial provisions for any children, the reasonable opportunity of each spouse for future acquisition of capital assets and income, the tax consequences of the property division. A minority of states will consider marital misconduct. Again, we talked briefly before about distributive awards in the state of Ohio. Those can be sought outside of the property division. In a community property jurisdiction, the marital assets are essentially divided equally. The general rule in most community property states is that the courts may consider conduct when dividing the marital estate, particularly economic misconduct such as dissipation of marital assets, concealing assets, or disposing of them in a fraudulent manner. What are the paralegals' role in the property division process? Tasks commonly performed by paralegals in property division cases include the following: helping to compile an inventory of the parties' assets and liabilities, drafting discovery requests, such as requests for production of documents from employers, and deposition questions and interrogatories relating to factors considered by the court, such as dissipation of marital assets, drafting motions, supporting affidavits, and proposed orders if required, such as a motion for appointment of an appraiser, researching governing law, statutes, case law, and secondary sources relevant to disputed issues, such as the treatment of professional goodwill of a business or the proceeds of a personal injury award, drafting property provisions for inclusion in separation agreements, addressing assets and liabilities, and helping to prepare exhibits for use in negotiations, hearings, and at trial.